Hi, my name is Alex Dolphin, and welcome back to another episode of Ex Ante. Today we're going to discuss the case United States versus O'Hagan. This case was heard in the Supreme Court of the United States in 1997. Go ahead and jump into the facts of the case. So Mr. O'Hagan was a partner at a law firm of Dorsey and Whitney. His law firm was representing a company in its acquisition of Pillsbury through a tender offer. Now, he wasn't involved in representing Pillsbury in this acquisition, but his law firm was. And so he found out through the law firm information channels that, hey, Pillsbury is going to get acquired. Pillsbury is a public company. So what he does is he goes ahead and buys call options, meaning he thinks the price of Pillsbury is going to go up. Well, he doesn't think, he knows, right? Because the stock price is going to go up once the tender offer is announced, which is a premium to the current trading price. So he buys a bunch of call options, places a massive bet on this, profits $4.3 million, right? So kind of seems unfair. How'd this guy, make $4.3 million? Well, he did it because he found out that the deal was going to happen before anyone else. And so the SEC and the Department of Justice also felt the same way, and they charged him with securities fraud and insider trading was the basis of that. Section 10B of the Exchange Act and Rule 10b-5 were the basis for those security fraud claims, which what we'll discuss here is the case focuses on insider trading. So in the district court, Mr. O'Hagan was convicted of his securities fraud violations on the basis of the misappropriation theory of insider trading. In the Eighth Circuit, the court overturned the district court's ruling saying, hey, look, Mr. O'Hagan, he was not an insider, right? He didn't work at the corporation, so he didn't owe a fiduciary duty to the corporation. He was representing the law firm. He was working at the law firm that was representing the acquirer, not the target, right? So he had no relationship with the target. He had no duty to that corporation or its shareholders. He wasn't an insider. So this isn't insider trading. We're going to reverse the conviction and let him go away. The SEC is not happy about that. It's been pursuing this theory of misappropriation, this misappropriation theory of insider trading since, for years. And the court mentions this, that the SEC has been pursuing this theory since Chiarella, which was one of the first big insider trading cases where the court said if you don't have a duty, then you can't be liable for insider trading. So here the court revisits that misappropriation theory. It revisits the SEC's argument, and it ultimately says that, yes, we're going to maintain the classical theory of insider trading, which is that if insiders with a duty to the shareholders trade on material non-public information, then they're liable for a violation of 10B for use of a deceptive device in connection with the purchase of sale or security. Now, also, we're going to expand that and create another layer of insider trading liability called the misappropriation theory. And what this states is that you engage in securities fraud if you trade on insider information in breach of a duty owed to the source of the information. Now, a duty owed to the source. So in Mr. O'Hagan's case, the duty owed to the source came from the law firm, right? Because the law firm was a fiduciary of the company. And so there's a fiduciary duty of the source. And you can see really quickly how much broader this is going to make the insider trading laws in the United States, because instead of having a duty to a particular corporation, it's just a duty to the source of an information. And that doesn't mean that you have to, it absolutely means you could be liable for using material non-public information about one company to trade, options on another company, because you know that this information is going to impact that other company. So it sweeps and broadens insider trading significantly in the country. And so the specific test is there has to be a duty owed to the source of the information. Now, that most often is going to occur when there's a fiduciary relationship to that information. And then when that fiduciary tells the information to another in a place of confidence and trust. And so when Mr. O'Hagan found out about the Pillsbury acquisition from his law firm partners and from the law firm info channels, he got this duty of trust and confidence was also engrafted onto him. Now, it was deceptive, the court says, and this is essential for the misappropriation theory. It was deceptive because Mr. O'Hagan traded on this material non-public information without disclosing it to his principal, so without disclosing it to the corporation. that is the key for deception to sweep under 10b or 10b5, right? Because the statute requires that there be deception or through a deceptive device in connection with the purchase or sale of a security. And so the deception, they say, is the traders trading without disclosing that they are going to trade on that inside information to the principal. So in this instance, Mr. O'Hagan, if he would have disclosed that he was going to trade on this, then the SEC's theory would have fallen apart. Now, we see in further cases that the court basically, circuit courts, in particular, not the Supreme Court, at least that I'm aware of, have said that if you deceive when you get that information and then you disclose, but if you were deceiving when you got that information, then you still might be liable for insider trading. As you can see how nebulous this misappropriation standard is something that the SEC would absolutely just love, and they do love this because it just broadens insider trading significantly. Now, that is essentially Justice Thomas's complaint. He says information could be used for many reasons. We're saying the information had to have been gathered in a deceptive manner in connection with the purchase or sale of a security. And that's not the only reason why, you might have gotten this type of information. This guy's a law firm partner. He has friends. These people talk about their careers. And he says it just broadens insider trading too significantly. This is criminal liability that Mr. O'Hagan was facing, right? Time in federal prison. Now, if we're going to do that, Justice Thomas says we need to have a little bit clearer standards, right? This is kind of just this nebulous theory that was grafted on after the fact. That Mr. O'Hagan didn't really have a lot of notice about what was going on here, a lot of fair notice that we would associate with due process, like of the Fifth Amendment, of the 14th Amendment. We're thinking about void for vagueness here as well. And so Justice Thomas throws back at that. The case also talks about the SEC's ability to create a rule on tender offers. I want to focus on that. I want to focus on misappropriation theory of insider trading. And so just as a recap, if someone trades in breach of a duty owed to the source of information, meaning that they received information that was confidential, they used that information to trade, and they didn't disclose it to the source of the information, then they might be liable for insider trading based on the misappropriation theory. And Justice Ginsburg, in the majority opinion, just wants to reiterate that, we understand that this is a broadening of the act. It's not inconsistent with a broadening of insider trading rule and common law. But it's not, it doesn't contradict the Exchange Act. It doesn't contradict the prior opinions, and it ensures and promotes the purpose of the Exchange Act, which is to provide and safeguard fair and efficient capital markets and capital formation in our country. I think this is a controversial case. I think it's such a broadening of insider trading without, really true fair notice, in the sense that you might have laws or rules or regulations that are written about it, could be seen as problematic, right, by some folks. Now, at the same time, you can see the side of the case where the court has concern about fair and efficient markets, and if we're having people that are, basically getting, in essence, this inside information and then trading against others that don't have it, well, that's basically the same as theft. And so we need to do something to prevent that. And I think that's the concern that's really animating the court's decision here. It doesn't help that it's a wealthy law firm partner that made $4.3 million. The SEC was probably tactical when it chose its defendant here to pursue the misappropriation theory. So if you like this video and you'd like to see more, go ahead and hit that subscribe button. And I hope you have a nice rest of your day. Bye-bye.